Hey out there, legal warriors. In this video, I'm going to cover what to do and what not to do if you're trying to get your property back, if you're currently restrained by a criminal no contact order or a civil protection order. This is a constant problem. If you have some type of order against you, you don't have your stuff, you don't have a way to have clothes or even your work materials. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like it, please subscribe. More people get to see it, more people get the help they need. I'm just going to jump right into it. So oftentimes in our practice, people come to us and they are currently, when they're talking to us, restrained by some type of criminal no contact order or a civil protection order. So criminal no contact order is where the court has typically ordered someone accused of a crime, oftentimes an assault charge or something like that, oftentimes a crime of domestic violence. They said, hey, you can't have any contact with the alleged victim. You can't go back to your house because oftentimes you are living with whoever the alleged victim is. In a similar situation, a civil protection order oftentimes has people that were living together at the time the petitioner petitioned for the order, and now the respondent in this civil case gets thrown out of their house while the case is going on. And when the officers come to serve that protection order, they just say, get out. They don't give you a lot of time to get stuff. And of course, in the criminal case, oftentimes the defendant is getting arrested. So certainly they don't get to take anything with them except maybe the clothes on their back and maybe their cell phone if they're lucky. So what happens then? People need their things, right? They need their medicine and their toothbrush and some clothes and the work computer or work tools if you're working the construction, maybe a car even, things like that. And so in these orders that restrict the defendant or the respondent in these two circumstances, oftentimes the court will check a box that will allow the person restrained one-time civil standby, a one-time civil standby. And, what do those words mean, a civil standby? It's not even explained on the orders, which is really super annoying because they could certainly explain what a civil standby is. Occasionally, if that no contact order is getting set in court, the judge will explain it some. But if it's a civil protection order, there's no judge talking to the person being served. They just get thrown out their house. So a civil standby, think about it this way. It's where the court is ordering the police to accompany the restrained person to their former residence, in this hypothetical, so they could obtain essential personal belongings. Essential personal belongings. That's the idea. And it doesn't really say much more than that. Occasionally on a civil protection order, it lists some things that they're allowed to get, especially if it's the petitioner. Sometimes the petitioner leaves and they want to get stuff from the respondent's place because, they fled the situation. But in any case, if you're the restrained person, you need your things. And so how typically does a civil standby work? Well, typically, you're going to have a copy of that order that allows you the civil standby. It restrains you and also has civil standby listed. So what you need to do in those situations is you need to contact the local law enforcement agency that would serve the location of the property. So if you're in the incorporated city limits of Lynnwood, then you would get a hold of the Lynnwood Police Department. If you're in the unincorporated area that's still called Lynnwood, which in other words the mailing address says Lynnwood, but you're in the county area, then you would need to call Snohomish County Sheriff. If you're in Seattle, City of Seattle Police. If you're in Puyallup, City of Puyallup Police, etc., etc. And if you're in a rural area, you typically are going to call the sheriff. And what you're going to want to do is you may want to try to call the non-emergency line, although you can call the emergency line. Try to find the non-emergency line and then say, hey, I have a civil standby issued in this case and a no contact order or protection order against me. Can you tell me how it is that you're currently having officers assist in civil standbys? Because each department's going to be different. And let me tell you, the judge probably doesn't even know how it's done because they're not out there in the field, right? They don't know what's going on and things change. No one tells anybody. And your attorney may have a decent idea from talking to clients, but also we don't really know for sure either because we're not out trying to get property. So you need to call that law enforcement agency and then listen up for what they want you to do. They might tell you sometimes, and everyone's going to be different, they might tell you, hey, get within a legal distance from the residence in question. If it's 1,000-foot restriction, don't get within 1,000 foot. Be outside of 1,000 foot, but otherwise nearby, and then call the non-emergency number, something like that, to see if an officer can respond. Oftentimes, that's what clients will tell us that they've been instructed to do by the law enforcement agency in question. And so just follow what they say. And we have to remember, though, when we go to this civil standby, it's totally discretionary with the law enforcement officer about how they're going to run this civil standby situation. What are some pitfalls to avoid? Well, you want to make sure that you have enough people with you. Maybe you can bring a mother or a father or someone else to help you get stuff in this short period of time. You want to make sure that you have an ability to take away what the officer needs you to take away. And you also have to think about when might be a time that you actually know that the protected party might be home. Now, we might think we want to avoid the protected party being home, but what I've seen mostly is law enforcement wants the protected party present so that the restrained party just doesn't rob the whole house of stuff, right? Because in the law enforcement's idea in their brain is that the person needing the civil standby must be in the wrong, so we're going to protect the person who the order protects, right? The whole purpose of the officer being there is it's sort of an exception to a violation of the order to be within that 1,000 feet or to be on the premises to execute the civil standby. What you don't want to do, though, is you don't want to violate other provisions of the order during the civil standby. You cannot talk to the protected party during this time you're on the property. You can't say, by the way, where's my coat? If an officer sees you say that to the protected party, they might arrest you for violating the order. A civil standby does not eliminate all parts of the order. It's an exception for you to be within the distance restriction or on the property with law enforcement there for the sole purpose of obtaining those essential personal effects. And so what are some things you want to think about? Well, we want to be pretty friendly to this law enforcement officer if we can, because they're going to use their discretion in what you're allowed to get, how long you're allowed to be there, that type of thing. The more we act sort of difficult or hurt or upset or pissy, right, then the officer might act that way back. We also have to realize that we're not likely going to get everything that we need. We're not going to be able to get furniture. We're not going to be able to get anything that the protected party doesn't want you to have. Law enforcement is not going to settle property disputes about who owns the Xbox and whether or not you get the Xbox or not. They're not going to do that right there, dealing with that situation. So when you're showing up, you are only trying to get what you need to live in the immediate future. It is not something to get you set up for the next 6 months. Although I wish that's what it was, that's not. So that's how a civil standby will typically work. You typically only get one, and it needs to be marked on the order. If it's not marked on the order, then you need to talk to your attorney about trying to get it marked in the order. Can you get a second civil standby? Well, if the court authorizes a second one, and sometimes they will on a new court date, then you might be able to get a second one. So what happens, and how do you handle a situation if the protected party is somewhat cooperative and wants you, as far as you know, to get your stuff? Because sometimes the people that are protected don't want the protection, right? In a criminal no-contact order, oftentimes the alleged victim doesn't want an order. Or even if they do want an order, they are kind enough, they want you to have all your stuff. Well, an officer's not going to help you get all that stuff. So in that situation, you may need to have someone else get the stuff for you. And this is where we need to be careful. In our opinion as defense attorneys, it is not a violation of a no-contact order to have someone else go there and get your stuff as long as they don't pass a message from you to the protected party. In other words, in our opinion, we would believe, and we would argue, and many prosecutors think the same thing, that let's say your good friend Bill wants to go to your former residence to get your stuff. Well, Bill can go to the residence and say, hey, I'm here to get restrained parties, items. Is there anything that you would like me to take away? Right? That didn't pass a message. Bill said why he was there. Didn't pass a message. Didn't say in this situation, restrained party says give him his stuff. No, that would be a violation. And so if the protected party is cooperative with your family or cooperative with a friend of yours, don't be afraid with the right, telling them not to communicate a message. They're allowed to go and get stuff because that friend of yours or that family member of yours is not restrained. They cannot have third-party contact where you're instructing them to pass that message on, but they can otherwise exercise their own free will in trying to get you what you need. Your car's there and the protected party wants you to have the car. You can't go within 1,000 feet. Well, someone else can go there for you, right? So just think about it that way. Occasionally we get an idiot prosecutor or an idiot police officer who will think that type of action is a violation. And it's 1 in a million we run into that. So you do have to be careful, because any time we're sort of dancing around what's a violation or not of a no contact order, other people may have their own opinion. And though we would win that type of argument, typically having to go through that is pretty difficult. Although normally speaking, we don't see problems when we have a third party who's not passing a message trying to get stuff from a cooperative person. If the other side's not cooperative, if the protected party's not cooperative, then it's a nightmare. You're just stuck, right? You're not going to have your stuff. You're going to have to sue them later. That's not going to get settled in the criminal aspect of the case or likely in the protection order aspect of the case. So I really urge my clients to try to be patient. The people really want to feel fairness in the system. And I think we probably are living in the real world where we understand that there's very little fairness when it comes to someone accused of wrongdoing, right? An innocent person accused of wrongdoing will be treated just the same as a person who actually did wrongdoing. And those innocent people accused of wrongdoing, it really is terrible to feel that's how you're being treated. But remember, it's a snapshot in time. Right? This is a temporary thing. The problem is with this temporary thing that it's very inconvenient because you don't have your stuff. And so that's what I could tell you. Don't screw up. Don't get too close to the property within a distance restriction if you're trying to get that civil standby. I've seen people get arrested doing that, believe it or not. What a nightmare that is. And also, don't fall for the trap where if the protected party talks to you, you think you're able to talk back to them. Right? It's not a violation of the order for the protected party to talk to you. They're not restrained. It is a violation of the order where you get to go to jail and get charged with a new crime if you respond to the protected party when they reach out to you. That could be by text, email, face-to-face, you name it. We can't deal with what's fair or right. We have to deal with what is, and then we'll let your attorney argue for what's fair or right in court when the time comes. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. And more importantly, if you have a criminal matter or even a protection order matter in Washington State, feel free to reach out to our firm. We've been doing this for more than 20 years. If we get on board, we'll listen to what happened, we'll identify a way forward, and we'll be there for you. Thank you.